Thank you. Good morning, everyone, and welcome to Reinhart Berner's webinar on managing False Claims Act compliance in the pandemic. And we're going to talk about taking steps, among other things, to minimize risk. My name is Mark Camelli. I'm going to serve as a moderator today. I want to thank you all for joining us on a topic that, while it's more than 150 years old, believe it or not, it's more relevant today than ever. Our panelists plan to present for about an hour and leave around 30 minutes or so for questions. We are going to be applying for CLE credit. Donna mentioned to you that you should be submitting your questions in writing using the GoTo app. We're going to either take those at the end or perhaps during the presentations, depending on the context and the type of question that it is. I want to just make some quick introductions here of the panelists. In addition to myself, I'm joined by my colleagues, Tom Burnett, Ryan Stipik, Dan Murphy, and David Pillay. Our perspective today is really informed by the experience of some of us in the public sector as prosecutors, and along with a substantial collective experience in handling these cases across a wide range of industries. Short, relevant biographical information is on the slides, and Tom can maybe advance that to, we won't go through all of that, but the slide program itself will be forwarded to you at the conclusion of the program, as will, I understand, the video recording of the program. Let me briefly go over what we plan to cover today. We're going to start with an overview of the False Claims Act. We're going to talk about particular False Claims Act risks that are presented by COVID-19 relief programs. Also going to talk about recent enforcement trends and risks. And then finally, best practices to minimize False Claims Act exposure. So with that background and welcome, I want to now turn it over to my colleague, Ryan Stipik, who will present on an overview of the Act. Ryan?
Thanks, Mark. Good morning, everybody, and thank you for joining us today. So what is this False Claims Act? Where does it come from? As Mark mentioned, it's about 150 years old, and it was actually passed during the Civil War, when the federal government was buying, equipment from Ironside vessels, which were the first metal ships fought in war and precursor to the battleships, to uniforms, encampments, and all those types of things for the Civil War. And what was occurring at the time was that there were a lot of people ripping the government off. And so this False Claims Act was passed to try and give the government some remedies. There were major amendments in World War II and major amendments again in 1986 as the substantial increase in Cold War defense expenditures occurred. And so the commonality here, where is their focus on the False Claims Act with the federal government from either a legislative or enforcement perspective, is when the government is significantly active in the marketplace, when they're purchasing incredible amounts of goods or services, and government officials can be overwhelmed by the amount of fraud. There can be opportunities for for people to defraud the government. Now, notably, this is a civil, not criminal law. Although in False Claims Act investigations, the Department of Justice is involved, and those can turn criminal. And there are a number of different criminal statutes that cross over, and the same conduct that can result in Civil False Claims Act liability can also result in criminal liability, namely 18 U.S.C. 1001, which punishes false statements knowingly made to the federal government or agencies thereof, which is punishable up to 5 years. 15 U.S.C. 645 prohibits making knowingly false statements for the purpose of obtaining a loan. And other statutes prohibit false statements made to a federally insured bank. All of those obviously are apropos to the loans, the PPP loans and such that we'll talk about later. And also notably, there are dozens of states that have their own version of the False Claims Act, including Wisconsin. So let's take a look at some statistics here of what has occurred since the last major amendments in 1986. $62 billion have been recovered by the federal government since that time. And in the last fiscal year, which ended at the end of September, October of 2019, the government recovered $3 billion. 2.1 billion, or 2/3 of that, resulted from these Quitam suits, which I'll talk about in just a minute. And during that same fiscal year, 633 new Quitam cases were filed, an average of about 12 per week. So the focus, I would expect that 3 billion to go up in the coming years. It was actually more than 3 billion in the years past, following out of the last the global financial crisis and all the government programs that came out of that, and the numerous False Claims Act cases that also came out of that. So what is a false claim under the statute? Well, it's broadly defined as any request or demand for money or property, and notably can also include avoiding payment of money or property to the government. And so the first two bullet points here on this slide address false claims when a person or company is trying to get payment from the government. And the second two are address the issue where a person or company is trying to avoid payment to the government. So essentially, anytime you submit a false claim or make a false statement or false record in order to get a claim paid, or in order to avoid paying the federal government, that would fall within the broad definition of making a false claim. So essentially, if you're doing business with the government in any way, shape, or form, you're subject to the act. Now, what's the mental state for a False Claims Act case? On the one hand, if you make a false claim by mistake, by negligence, that's not actionable. On the other hand, of course, if there's specific intent to defraud the government, and the first bullet there, actual knowledge of the false claim or statement, that obviously is actionable. And there's lots of gray area in between negligence on the one hand and fraudulent, specific fraudulent intent on the other hand. And that's the other two bullets where you make a claim with deliberate ignorance of the truth or falsity of the claim, or with reckless disregard of the truth or falsity. And again, that's a kind of gray area. Where does negligence end and reckless or deliberate ignorance begins? It gives wide latitude to the government and these Quitam relators in asserting claims.
Ryan, if I may, just to add here for context, then, as we talk about later, best practices, these issues of actual knowledge, deliberate ignorance of the truth, reckless disregard of the truth, underscore the importance of documenting your deliberative process for making claims. And now that changes. If you're in the healthcare area, that could, and you're doing multiple claims in a day, right? You're seeing 20 or 30 patients. That's a different kind of documentation, although even then, right, there is a requirement that you document medical files. But how you do this in the context, for example, of these, for example, the PPP program is very, very important as far as how did you get to a position that you believe entitles you to make the claim. So keep that in mind, and we'll come back to this when we talk about ways to protect yourself.
And so there's throughout the years, there have been some common theories and fact patterns that have developed, and here's 4 of the typical ones, and the panel later will discuss, how these different theories may apply to the programs that have been instituted as part of the pandemic response. The first one is pretty obvious, making an express false statement in the claim for payment. We see these oftentimes in defense contracting or supplying goods to the government, where the parts either don't meet the specifications of the contract, and therefore a certificate of conformance is false, or there have to be certain testing procedures done on the products, and those testing procedures are either inadequate or done incorrectly or fudged. Those are typical kind of fact patterns for that theory of the claim. The next one, implied false certifications of compliance with laws and regulations. This can be very broad. Often the government contracts require that the contractor be in compliance with kind of general laws and regulations that might not even be specifically applicable to that contract. And by submitting the claim, you are impliedly certifying that you have complied with all these other laws and regulations. The third one, fraudulent inducement of a government contract, is where a contractor makes false statements in the bidding or submission process. And the notable part about that theory is that if the contract is obtained through fraudulent inducement, it can render all claims for payment under that contract as a false claim under the Act, and subject to the penalties and recovery provisions that I'll talk about in a second. And then the last one there is reverse false claims, which is common in healthcare, where a claim is submitted, you learn that you were overpaid. There's an obligation to pay that, to return that money promptly. So what are the remedies under the Act? There's civil penalties that range from about $11,000 to $23,000 per false claim submitted. And so that can rack up very quickly. Then, in addition to that, to the extent that the amount of money paid improperly, the government or the plaintiff can recover 3 times the amount of the damages. And so, for example, with the PPP loan, if that was obtained improperly, the exposure there could be 3 times the amount of the loan. Statute also provides for payment of reasonable attorney's fees, but there are also these collateral impacts of running afoul of the False Claims Act. And a big one is suspension or debarment. This can be huge if contracting with the government is a big part of your business. A follow-on impact often of these investigations and prosecutions or lawsuits is suspension or debarment from contracting with the government.
Ryan,
And
let me
then-
just, if I may, just step in for just a second here. Suspension and debarment, meaning you are prohibited from participating in any program, government programs. And it just doesn't mean, it doesn't just mean the type of program that you might be already in. It also has even further secondary collateral impacts on, for example, a person's ability to get guaranteed student loans. So there's a whole host of secondary collateral fallout from suspension and debarment. In the area of healthcare, you know, where you're talking about healthcare systems or physicians being debarred from participation in the Medicare or Medicaid programs, that puts them out of business. So just a comment there on how there could be these secondary costs, and Brian's going to touch on the hard costs that can follow as well.
Yeah, so let's, we mentioned the Quitam Actions and a couple times. What is a Quitam action? Well, the full Latin phrase is Quitam pro domino rege quam pro se ipso in hoc parte sequitur. Thankfully, we don't have to say that very often. We just call it Quitam. But it means he who sues in the matter for the king as well for himself. And so this aspect of the law essentially delegates the power in some ways of the federal government to private citizens to seek financial recovery on behalf of the government and take their share of the pie that is ultimately recovered. The share of the pie depends on whether the government does or does not intervene in the case directly, which I'll talk about in a second on kind of the overview of the process. If the government does intervene, the relator, the Quitam plaintiff, can get 15 to 25% of the total recovery. And if the government does not intervene, they can get 25% to 30% of the total recovery. So it's a large, it's a large incentivized, it's a large piece of the pie to incentivize these plaintiffs, and there's a whole plaintiffs bar dedicated to this area of the law. In terms of the procedure for these Quitam actions, you know, the whistleblower, the relator, and her lawyer will investigate the case. The relator is often a current or former employee, often disgruntled. There's no need that the person have to personally suffer any harm, and the person's not even disqualified, even if they participated in the wrongdoing alleged, although it can affect the amount of the award. The relator must be the original source of the information under the statute. It can't learn from newspapers or, you know, even hints about kind of the fraud that may be in publications. Once the relator files suit, that case remains under seal for at least 60 days, but usually much longer, as the government has given an opportunity to investigate the allegations in the Quitam lawsuit. So often the first hint that you'll find out about a Quitam lawsuit out there is actually a subpoena from the government or a civil investigative demand for records. That's often the precursor to the Quitam lawsuit itself being unsealed at a later date. Once the government conducts its own investigation, it can either intervene in the case and essentially take it over from the Quitam plaintiff. It can settle the case after its investigation without further proceedings. It can move to dismiss the case. This is occurring with somewhat more frequency, although still quite rare. And so with that, that's the overview of the mechanics and background of the lawsuit and the incredibly large penalties and exposure. You know, we saw a significant uptick, as I mentioned, in False Claims Act cases coming out of the last financial crisis. Huge recoveries in the mortgage practice area, since mortgages were backed in many instances by the federal government. A ton of cases coming out of the Troubled Asset Relief Program, or TARP, and other programs, the stimulus program. And so we think there's likely to be a similar activity in this area coming out of the pandemic relief programs. And Dan is going to talk in more detail about those programs and the risks there.
Yeah, let me just point one thing out. At least one major federal district in this country who generates a lot of these cases, fraud, False Claims Act related cases, has reported that nearly all of them come from Quitam whistleblowers. So that's pretty powerful. And in the context of COVID-19 related relief programs, as Ryan points out, I think that you may end up seeing much of the same. So with that, let's turn it over to Dan Murphy to talk about how the particular risks associated with the False Claims Act are presented under the relief programs themselves. Dan?
Thanks, Mark and Ryan. I hope to highlight some of the ways that what Ryan talked about might crop up in COVID-19 relief programs, specifically PPP loans. The SBA has announced that there's a mandatory audit of any loan over $2 million. So obviously that's significant for recipients of that size of loan, but the implication there is that if it's mandatory above $2 million, there will be additional audits, not necessarily mandatory, below that threshold. The eligibility or the application to receive the loans have largely been submitted, but we are entering the time where businesses are starting to apply for forgiveness, and that application contains just as many, if not more, certifications relevant to False Claims Act liability. I've listed 3 here that I think are the principal ones. The application requires that the applicant certify that the funds were properly used, used for purposes of payroll, employee retention, fixed obligation expenses, that the funds were accurately calculated. In other words, that the funds coming in and going out for those proper purposes were accounted for accurately. And then that all of the statements in the application are true. So those 2 certifications, and then any others, that all of those are true. Any one of those 3 certifications could be a basis for liability. And then in addition to the actual statements being made in the form, the documentation submitted with it can also provide a basis for liability. The applicant has to provide documentation of the full-time equivalents in the coverage period and also in the reference period from 2019. Whether in the reference period or in the coverage period, if there is issues with that documentation that call into question the statements in the application, that could be an area where we see some problems. Also, the documentation for fixed obligation expenses, again, the idea if there's any sort of a mismatch between the documentation and the certifications in the application, that could be a potentially false claim. So provider relief funds, Ryan talked about a reverse false claim, where it's really the obligation to repay the government is not upheld. So these funds have been given to providers on the condition that they're used for certain purposes. And the problem arises, and where we see the concern is that what those conditions are. So the funds can be applied to expenses that are attributable to the impact of the coronavirus, while what's attributable to a provider in a certain circumstance may not be what the government deems attributable to the coronavirus. Likewise, all of the funds under the CARES Act cannot be used for expenses that are reimbursed for, quote, other source or by other sources. Again, any mismatch between a provider's understanding of what that means and the government's could lead to a potential issue. And finally, with respect to the provider relief funds, the Office of the Inspector General in Health and Human Services have interim reporting requirements to Congress, as well as at the end of the program, a final reporting requirement. And so as they have their obligation to Congress, of course, they will be conducting compliance surveys and audits of providers in order to provide that information to Congress. And where the potential for concern arises is that the provider needs to report that information accurately and also record that information accurately. If there's issues in that area, again, it could be a potential false claim to the government.
Dan, if I can just interrupt really quickly, one point that I think is important to remember with the provider relief funds under the CARES Act is that the first and second, so we're talking about the $50 billion and especially there's an initial tranche earlier in the summer of $30 billion to providers participating in the Medicare program. There was a second tranche of $20 billion. Those were paid automatically. They were deposited electronically in provider accounts, calculated based off of prior year's Medicare receipts. They're still subject to conditions in a lot of, at least initially, I think a lot of my clients in the healthcare space looked at this with the general understanding or the expectation at least that there weren't really strings attached. Well, that clearly wasn't the case based on what you're describing here, Dan. There were conditions on who was eligible to retain those funds, who was eligible to use them, what were eligible expenses based off of care, treatment provided, or revenue losses substituted for related to COVID-19. And I think the fact that they were deposited automatically in a lot of ways made it easier to overlook some of these concerns, because even though you received them automatically, you still had to make a certification that you were in compliance with those conditions. And if you failed to return the certification or attestation, you were deemed to have certified. And so that's where I think there's a likelihood that you're going to see a lot of exposure under the False Claims Act and especially in the healthcare space.
So another healthcare area where we see False Claims Act liability, potential for it, is the HHS waivers. This is the 1135 blanket and individual waivers of certain regulatory requirements. The blanket waiver related to COVID-19 is extremely long and very complex. Individual waivers are applied on an individual basis, whether by a provider or a state. So those would be a little bit more narrow, but especially with the blanket waivers, the concern here is that all of the claims for reimbursement that are submitted, the understanding is that those are submitted under with certification that the provider is participating appropriately in Medicare and Medicaid, and monitoring those participation requirements, I should say. The intention of the waivers was to provide some relief, to give flexibility. But the problem is that there are so many waivers they change, and that there really isn't a past practice because they're all so new, that the adapting the provision of care to account for the waivers can be, it can create potential for errors. So two ways that this may crop up into a false claim is interpreting the waiver in a way where you end up billing for services that are outside the scope of the waiver. In telehealth, the waiver increased coverage, it increased authorized services. So a provider interpreting that waiver could submit a claim for reimbursement that ultimately goes beyond what the waiver was intended to encompass. And then the kind of flip scenario is that it's correctly billed, but there are other compliance issues. And so as an example of how constantly these regulations are changing, just on Tuesday, the government announced that there are new testing requirements for healthcare staff and patients in healthcare facilities, as well as the number of tests available for testing of patients suspected to be infected with COVID-19. So a provider who's not paying close attention to those compliance requirements and adapting their systems to them may find themselves submitting a claim that ultimately was submitted at a point where they were out of compliance with the participation requirements. Government contractors are, kind of in the manufacturing field, always under scrutiny, like Ryan talked about previously, for submission of invoices, keeping records of payments of government funds. But what's different right now is that there are a ton of new entrants to that field. The government has increased its spending and procurement immensely during this time. And so there's new government contractors, and then suppliers to those contractors can also find themselves, depending on the circumstance and their level of awareness about the government contracting involved in the agreement that they have to supply the government contractor, can find themselves submitting claims to the government. So the claims here, like I said, are really a little bit more straightforward than we've talked about in the healthcare context. It's an incorrect invoice, an incorrect record of payment, or a concern about skimming that government funds received are not necessarily paid out as intended. There is also within the CARES Act specific relief for government contractors to keep their workforce in a ready state. There's reimbursement for paid leave, and that those funds raise the same concerns as what we saw with provider relief, that there's the potential for double dipping, that some other coronavirus related relief is used for reimbursement of that expense, and it raises an issue that I'm sure Tom will talk about in more detail, that it's extremely important to keep track of these funds coming in and these funds going out.
I can just jump in and touch on that new entrance into the field issue. We've handled a number of cases where this issue crops up. Someone jumps into the field of government contracting, and getting into it, they think, well, it's just like selling to any other customer. And no, it's not. There are a host of regulations that you have to be aware of when you're getting into this field, and have to have compliance measures in place when you get into it. And Tom is going to talk about, in some depth about those compliance measures. But people that just jump into government contracting without thinking about those things ahead of time are going to run into trouble.
And so we anticipate the increase in enforcement for a number of reasons, probably principally because there's so much more money the government, that they're, much like even the very old example of the funds in the Civil War, where there's an influx of funding, the Civil War or the situation in 2008, there's going to be increased oversight of how those funds are used. The Department of Justice has created a coronavirus fraud task force, and they've, in each U.S. Attorney's Office, have a coronavirus fraud coordinator that's specifically looking into these issues. And just maybe an obvious point, but just because it comes out of the Department of Justice, that would still be a civil action. So it doesn't mean that those are just those criminal liability concerns. The whistleblower hotlines are posted on any department or agency that is related to the administration of these relief packages. The SBA, the HHS, CMS, really any agency involved in these funds has very prominent advertisements for whistleblowers to identify and report fraud to them. Like Ryan talked about, there's a whole bar of attorneys chomping at the bit to bring a claim like this on behalf of a whistleblower, and are actively seeking out those claims beyond what's just posted on government websites. The Congress has established the Pandemic Response Accountability Committee to monitor these programs. It's composed of inspector generals from many departments, but certainly the departments most involved in administering these funds, the SBA, and then also departments monitoring that use of funds, such as the Department of Justice. And also there's mandatory audits on the congressional level, looking at how these agencies are monitoring the funds, and then, kind of a trickle down, the compliance surveys and audits conducted by those agencies recipients of funds. Just this month, CMS announced that it's restarting, it had paused its routine compliance survey practices, but it's restarting that, and also restarting its enforcement actions. And just this week, a former Attorney General, the director of the Civil Division, Jody Hunt, who recently stepped down and joined private practice, gave an interview regarding his expectation that there will be increased government scrutiny. He made the point, and I think it's a good one, that doesn't necessarily mean that there will be more cases. That'll depend a lot on what Tom has to talk about. If these funds are used appropriately, the government doesn't want to, chill the desire to respond to the pandemic with, that's the whole purpose of these funds. But nonetheless, the scrutiny, given the amount of funds involved, will be great.
Well, thanks, Dan, very good. And we're going to turn now to David Pillay, and David's going to talk to us about recent enforcement trends. David?
Thank you, Mark, and thank you, Dan. So Dan touched on some of the reasons we're expecting increased enforcement. There's been a massive sort of enforcement and oversight resources assembled. I'm going to try to give you a little preview of the types of things we're seeing early on, and then where we think those will eventually lead and why. So as typical with the government, what we're seeing initially is going after low-hanging fruit, essentially. And in the context of the FCA and the COVID relief funds, that is initially shaping up as the sort of objective false statements that Ryan touched on earlier. We also have seen a number of indications from the government that they intend to target criminal activity initially, though as Ryan said, in the FCA context, criminal and civil liability can go hand in foot. The government can go after, a particular actor at a company that can spin into a civil case for that company, and vice versa. In March, Attorney General Barr made the specific point that the government was going to target criminal activity in its oversight of these funds. However, if history is a guide, we know from all the relief funds that were released after the financial crisis in 2009 with TARP and things, that the FCA cases eventually ballooned. I think, there were over 4,000 cases brought in that 5 years after that, and $23 billion of recovery. A lot of that stemmed from whistleblowers. So as Dan and Ryan have touched on and alluded to, what Tom will talk about in more depth, that's really where we see things going in the long run. The government will start with the low-hanging criminal fruit, and then eventually whistleblowers, relators, and their attorneys will pick up the wand. So just by way of example, a few of the cases we're initially seeing start with one of the theories Ryan discussed, which are just express false statements to the government. These are sort of black and white cases that the government can bring really easily. There was a case where a Massachusetts-based IT company that it was a real company, it was really operating, submitted applications for PPP loans, and in doing so, it fudged its numbers on the number of employees that it was asking for payroll assistance with, and the number of companies that those employees worked for. So it essentially just inflated itself in those loans. As Ryan said, there are criminal statutes that prohibit making false statements in order to receive loans from federally insured banks. And so this was a pretty easy case for the government to prosecute. Again, a real company, just embellishing. A little further down the spectrum, we've seen the government uncover what could better be described as sort of a more overarching scheme to sort of suck money out of these relief funds. Another company, there was a Washington-based software engineer who did have at least one real operating company that he operated as a sole proprietorship. But when he went to seek loans from the PPP program, he actually decided to create new companies so that he could leverage the amount of loans that he could apply for. And in those new companies, new employees were invented. So this, it became easier for him to justify. Again, this was a false statements case. So this person, in keeping with the little bit more egregiousness of this scheme, I think he was actually backdating his tax documents. It doesn't really work well to apply to the government for reimbursement of payroll for employees that are part of a company that was created yesterday. So while these companies were actually incorporated yesterday, he actually just changed the dates of those tax ID number documents to go back to 2018 and 2017, so that the loan processors wouldn't raise any issues, and it wouldn't trigger those sort of red flags that banks have. Again, this was a pretty easy case for them to prosecute. The third example actually seems like the most colorful of the three, but for a few reasons I'll discuss, we actually see this as an example of the type of case that the government will likely bring in the future, and that could more directly affect companies. So in this particular case, there was a Hollywood producer, which is what, sort of one of the details that makes it colorful, that applied for loans for a few production companies that he had, and there are no allegations that that he didn't actually qualify for those loans, and that his companies weren't actually being negatively affected by the coronavirus pandemic. What happened here is that when the government looked at what he actually did with the loan money, that's where the issue arose. So instead of an outright false statement on the application, though there are that too for other reasons, this actually moves into a different theory that Ryan touched on a bit, which is the certification that the loan proceeds are going to be properly used. And you have to certify when you apply for these loans that they're going to be used for certain types of expenses, payroll, rent, utilities, business expenses. In this situation, I think the person took $80,000 and paid off his credit cards. He took $40,000 and paid for his car. Dan sort of touched on the potential disconnect between what the recipient of a loan sees as proper use and what the government sees as proper use. You could make a case for a Hollywood producer. Maybe in his mind, he thought, he needed to max out his credit cards and have the best suits and the best cars in order to, wheel and deal in that world. But the government didn't see it that way. So this was, again, a criminal prosecution. However, it does highlight how we see this developing for companies, which is that, a company may be truly and genuinely affected by the pandemic. It may, truthfully and genuinely apply for loans in order to mitigate its circumstances. But, often with the help of whistleblowers internal to the company, how those funds are actually spent over the next months and years could create potential liability. So it's a policing of the funds afterwards. We've seen, as I said, we anticipate as in the history has shown that civil and criminal cases will be brought in sort of an overlapping way often. The government has said on multiple occasions, I quoted Attorney Barb for Brian Benchowski was, he recently resigned, but he was the head of the criminal division at Maine Justice, also reiterated that, the government intends to bring criminal prosecutions here. But, more recently, actually in his resignation, Assistant Attorney General Benchowski made the point that businesses are also going to be targeted. And we know that businesses are more often targeted with civil enforcement than criminal enforcement, though both are certainly possible. So Dan touched on one of the main reasons that we think that whistleblowers are going to play a huge role in the next sort of wave of enforcement actions. And that's because the Treasury Department, after some pressure, decided to create, mandatory audits for recipients of loans over $2 million. But more importantly, they also released the entire list of all the 5 million businesses that received loans under the PPP program. And so that gives, entrepreneurial lawyers out there, as well as potential relators internal to the companies, a starting place to verify that their company has, truthfully applied for these loans and then properly used them after receiving them. So we sort of think whistleblowers can act as private auditors. So sort of like the film producer case that we talked about, the type of action we foresee is that, maybe perhaps a whistleblower internal to the finance department of a company going through the books and records, looking at the loan applications, may trace out, how they believe those funds were actually allocated within the company. Maybe circumstances change from when the loans were applied for. There will always be issues of fungibility and how you can trace whether the particular loan funds were used for these particular types of expenses or not. And whistleblowers in the government may have a different view of that than the company does. And just underscoring and moving into the particular risks posed by whistleblowers, this act, like previous similar acts like TARP, has specific whistleblower protections. There are also protections against retaliation. So whistleblowers are incented, as Ryan pointed out, by the potential to realize a huge portion of what can be those quickly, exponentially growing penalties. They're also, in some ways, encouraged by the fact that they are protected once they become a whistleblower from any retaliation. So it's sort of a nothing to lose, lot to gain scenario that the regulations create. And to sort of sum it all up, combine those huge incentives, the speed with which all this money has been dispersed, and then the ambiguity of these regulations. We talked about proper use, objective falsity, fungibility of funds, those types of things. And the conditions are sort of ripe for another wave of Quitam actions. And I think Tom will be able to delve a little bit deeper into that particular area.
All
Thanks,
right.
David.
Thank you. So thank you. We're going to move to Tom here in a second. No questions have come through yet. Keep those in mind and send them when you're ready. We're happy to address them. Again, as we present here or at the end. And we'll probably go another 15 minutes, Tom. What do you think before we take some questions?
Yeah, I think so.
Good.
So the big question here is, what can you do to protect yourself? And for all the reasons that David and Dan and Ryan have talked about prior to me taking over, I don't think it's possible to eliminate the False Claims Act risk stemming from COVID and program. The tool here is, what can you do practically speaking to try to mitigate that risk and minimize it as much as possible? The first thing, or the first steps that we're recommending to our clients, and really I think this is an evergreen recommendation for anybody that does any amount of business in the government, is to build a robust compliance program or establish an aggressive and effective compliance protocol internally. We've talked a lot, obviously, about some of these cases of very clear instances of objective fraud, and I don't want everybody who's here to get too comfortable and say, well, I'm not falsifying payroll records or creating companies that didn't exist previously just for purposes of getting relief funds or a PPP loan or whatever it may be, because the False Claims Act is susceptible to claims stemming not just from those instances of outright fraud, but from cases of abuse or even arguable abuse. And so what's most important is that you establish and reevaluate a compliance program, if you already have one, to make sure that you're aiming towards two primary goals of any compliance program: to obviously prevent fraud and misconduct in the first place, And the second is to detect past instances of impropriety or fraud or abuse, and to ensure that it's investigated, remediated. And the reason that's especially important in the False Claims Act context is not just because of the increased risks that we're talking about here, but compliance is something that the government takes very seriously. DOJ has issued guidelines for taking disclosure, cooperation, and remediation into account in FCA enforcement action. They come right out and they say that the department may take into account the prior existence of a compliance program in evaluating a defendant's liability. And to do that, I'd note, I suppose, that although they use the permissive may there, in my experience, it's something that always comes up when you're talking about what's it going to take to resolve an FCA action or a fraud and abuse investigation. They always want to know, what protections do you have in place? Did you have in place? How was the fraud discovered? And more importantly, how can we be comfortable that it's not likely to happen again in the future? Just a couple months ago, at the beginning of June, the Criminal Division at Maine Justice issued updated guidance on the evaluation of corporate compliance programs. Obviously, that's coming in a lot of ways from the criminal perspective. Like David mentioned, criminal and civil go hand in hand when you're talking about false statements, false claims under the FCA. I'd encourage everybody, if you haven't seen it already, to take a look at that and see the level of detail that Criminal Division at DOJ is expecting for compliance. One thing that the Criminal Division noted in those guidelines in particular is that there are 3 key questions that the government's going to ask in any false statement claim, or here we're talking about obviously an FCA case. And the first is the company's compliance program well designed? What that means is it integrated into the company's operation and workforce? Is there a top to bottom commitment to compliance? Is the company's leadership stress the importance of an ethical and compliant workplace? I think the most important point, really, for purposes of this discussion about FCA in the age of COVID is the 2 middle points there. Is that based on an appropriate risk assessment, depending on a variety of factors, including where the company's located, what the company does, what the regulatory landscape is, and really, most importantly, has your compliance program been periodically reassessed and updated? The expectation at the government level is that compliance is a constantly evolving concept. So it's important to remember, and especially with an eye towards the different relief programs, the different government responses that you're seeing in the pandemic, to kind of take a look at what you're doing and what you have in place and the protections and the staff you have on compliance issues. Make sure that they're evaluating everything and prepared to evaluate everything with an eye towards this changing climate, and specifically with an eye towards the risks that are presented by your participation in any particular government program. The second question, and I alluded to some of this earlier, is the program applied earnestly and in good faith? It's not enough to say we have a compliance program. It's even not enough to say we have a formal compliance program and hand over to the government a handbook that describes all the protections that you have. What the government wants to see is that you have more than just a paper program. You have to staff your compliance team with qualified personnel that are familiar, obviously, with the factual circumstances in which you operate, the legal landscape under which you're operating. And you have to make sure that your compliance team is adequately resourced, adequately funded, and they've been empowered to function effectively. And one thing that I remind my clients a lot is that Compliance is a shared responsibility. Again, this sort of digs into the criminal side of things, but the U.S. sentencing guidelines that come up in criminal cases obviously specifically call out that a company's governing authority shall be knowledgeable about the content and operation of the compliance and ethics program. High-level personnel shall ensure, again, that the organization has an effective compliance and ethics program. So the expectation is that leadership within every company is keeping an eye on, are we making appropriate certifications? Are we getting and keeping funds that we are actually entitled to? And it's not going to be acceptable for you to say, well, that was somebody else's responsibility. And the third question is,
Tom,
does the
Tom, may I ask you a question? May I just interject here? Yeah, when you go back to the last slide, when you talk about properly scoped investigations by qualified personnel, are you talking about internal or bringing external resources in? And what do you mean a little bit more, if you can explain on that?
Yeah, that's a great question. Thanks, Mark. It can be both internal and external, and I think it is both internal and external, and it depends in a lot of ways on the sector you're talking about, the context of an allegation, whether it's a potential whistleblower claim or sort of rumblings of past improprieties. I think the key is the government's expectation is that you're not just burying your head in the sand. And so if you have a compliance director that comes in and they see that there's, in the healthcare space where I do a lot of work, if you have a new compliance director that comes in and they say, our documentation is all out of whack. Past practices of my predecessors just weren't acceptable. I can see here, and here that, hospice documentation or home health documentation or whatever it may be just doesn't satisfy the appropriate standards. It's not necessarily enough to say, we can fix it and go forward. You've got to look back and you have to make appropriate decisions about where are you going to draw the line in terms of who we're talking to, what we're looking at, temporally, subject matter wise, because again, and this I dips into, especially with the risk of reverse false claims, the goal is to know what's there. It doesn't do you any good. It doesn't do us as FCA attorneys any good to hope that something doesn't come up, because the expectation, like we talked about a lot here, is that there's a commitment to compliance, to ethical practices when you're dealing with the government, and that there's likely to be involuntary self-disclosure. And so that's where properly scoped investigations, properly resourced investigations are especially important.
Yeah, and that is very, very important. That's why I wanted to underscore it, and the use of counsel in these to help guide these investigations where appropriate, particularly outside counsel for purposes of ensuring that privilege is maintained, for among other things. So thanks, Tom. Yeah, you can.
I think in the whistleblower context, which is in a lot of ways the most significant risk that we talked about here, it's especially important to work with outside counsel, just because I can't remember the last time I had a whistleblower claim or a potential whistleblower claim that wasn't alleging misconduct on the part of those that would be responsible for investigating. And so, in a lot of ways, as a practical matter, it makes sense to turn over an internal investigation to somebody outside of the company and make sure that it's properly handled. The third question that the government is going to ask is, does this, for purposes of evaluating compliance and whether or not you're entitled to some sort of credit for having a compliance program, is the one that works, actually is effective. In the hallmark, and this is something that comes right out of the guidelines and commentary that has come from DOJ is effective compliance program is its capacity to improve and evolve as business governing law and industry standards change over time. So when we're talking about COVID, let's be honest, is something that most of us, probably all of us, have never even expected to see, or at least haven't seen in I know in my lifetime, seeing government actions, and obviously everything that's going on in the world right now is unprecedented. And so you may have had an acceptable compliance program and acceptable compliance standards 5 years ago, but if you haven't taken a closer look at them based on the risk profile that you're now facing in light of COVID, changing laws, the changing regulatory landscape, you're probably falling short of it. So the next recommendations are actually sort of, I think, subparts of what makes an effective compliance program, with an eye specifically, obviously, to everything we've talked about here with the coronavirus and government response. The first is make your record now. Dan talked about the automatic audits of PPP loans of $2 million or more. I talked a bit about the provider relief funds that were paid under the CARES Act. Any payment that's made to a private entity from the government at any time, and especially in connection with the pandemic, comes with strings attached. I talked about that at the outset. Always, it's not as simple as doing business as an arm's length transaction with another private company. There are a lot of reasons that you should expect, frankly, will end up somebody asking questions. Unfortunately, I think the assumption ought to be either the government, whistleblower, or a government contractor that's engaged to audit is going to start asking us, were you eligible to receive funds? Were you eligible to retain funds? Did you use them for the appropriate purpose? And so in order to put yourself in the best position to answer those questions and protect yourself from key exposure, or the risk of a more serious enforcement action, whether brought by the government or whistleblowers, is to maintain the appropriate documentation. So when we're talking about, PPP loans, where you had to be able to certify that it was you were applying for a loan that was necessary to support ongoing business operations, what went into that determination? What records are you going to use to prove that you were in sufficiently dire financial straits to satisfy that standard, as vague as it might be? We're talking about CARES Act funding, the provider relief funds, where you had to prove that, or in order to be eligible to retain those funds, they had to be used for care, treatment, or prevention of coronavirus, or as a substitute for revenue losses stemming from the pandemic. How are you going to prove that that's what those funds were used for? And the time to do that is now. And so it's important that you complete, accurate, contemporaneous records of what you're experiencing right now and how it compares to past years where you weren't facing a once-in-a-lifetime pandemic. The second piece of it is monitor your own business, and as part of what makes for a good compliance team and compliance program is look for red flags that are likely to trigger even higher scrutiny than you're already seeing. The one big example, I think, or one most obvious example, is executive compensation. If you applied for funds saying you need this to support our ongoing business, and somebody within the company or outside the company finds out that your leadership increased their salaries, or they're maintaining what could arguably be considered an above market salary, that's going to put you in the crosshairs of especially whistleblowers and as well. And then the final piece of it, and this is something that I told every single one of my clients who was considering applying for funds, who received the provider relief funds and had to decide how they were going to use them or if they were going to use them, is I think it's just a simple, easy enough step is to segregate the funds that you're receiving as part of pandemic relief from your ordinary business finances. It's in a lot of ways, I think, we sort of look at money as fungible. Well, the government, especially when they're talking about these relief programs, doesn't view it that way. If they pay you, $1 million as part of a PPP loan that has to be used for very specific purposes, if there are other funds that you mix in between, and some of them are used for inappropriate purposes under those standards, and some are used appropriately, it's hard to trace where the dollars came from. And so segregating the funds in separate accounts so that you can make sure that you're limited to those appropriate uses and ultimately can prove it if somebody asks a question. The next piece of it, and this is a really, really difficult thing to do, quite frankly, is follow the changes in the legal landscape and the regulatory landscape. And the reason I say it's difficult is it's constantly changing. In the early days of the pandemic, we saw the rush of regulatory and congressional responses. It seemed like every single day there was a new law passed, there was a Constitution instituted, new guidance that came out to tell you what those laws and regulations meant. The very next day, you get supplemental guidance that would say something slightly different. And so it's a really difficult thing to do, but it's especially important because of the reverse false claim situation that we talked about, to know how things are changing. What are the expectations at this particular point in time? You may have been comfortable that you satisfied all of the requirements and standards for applying for a PPP loan, but if the guidelines or the standards for who's eligible to receive that loan has changed in the 3 or 4 months between the time you applied for and received the loan and the time you applied for, you're set to apply for loan forgiveness, you need to know what those standards are, because you may not be eligible for loan forgiveness based on the current standards. It's important, again, that based on that guidance, you're carefully evaluating any express certifications that are made in submissions you have to make to the government, but not just those express certifications, the implied certifications as well. Can you safely say that you are eligible to participate in these programs, and any representations along those lines, or any representations you make about products, if you're doing business directly with the government, are accurate? And then again, you have the record to back that up. One thing, again, of course, to remember is that guidance is only as good as it is, right? I mean, guidance is part of the difficulty that clients are having is sort of this rush to pass these programs based on somewhat ambiguous things. And then FCA and Treasury, when we're talking about PPP or HHS and HHS, if you're talking about provider relief funds, or any number of agencies that have hands on this, come out and they try to provide some sort of explanation for what those standards or requirements actually mean. Guidance really isn't any clear. PPP had to be necessary to support ongoing business operations. A lot of clients were saying, what the heck does that mean? FCA, a week or two after PPP passed, came out and said, here's what it doesn't mean. If companies with other adequate sources of liquidity are unlikely to qualify. So that tells us a little bit more, I suppose, than the first round of guidelines that we had, but it doesn't necessarily answer all the questions. And so you have to take in all of that information and make a thorough and thoughtful and reasonable analysis of whether or not to apply. And again, it's not a safe harbor just because guidelines at the time you did something suggested you could doesn't mean that you're safe forever. Again, because of the reverse false claim risk. We could talk for another 3 hours about administrative law and deference doctrines and how agencies can change their interpretation. I'm not going to do that because that would be a really boring presentation, and that's not what everybody signed up for. But it's just important to remember that the changing standards are important. And again, this is a situation where I think, when in doubt, consult with counsel. That's especially so if you're not accustomed to doing business with the government. And then the last practical step is develop a plan, develop a crisis response plan for not if, but when somebody, whether it's the government, whether it's a law attorney, whether it's somebody internally, is going to start answering these questions. Expect to be audited, prepared if you get a civil investigative demand and subpoena, and I'd recommend that you consult with counsel and not try to handle that stuff on your own because it's going to lead to something more significant. Be prepared for whistleblowers. I hate to say it because I don't mean to suggest that you shouldn't trust your employees and your workforce. But I think, especially if you want to be really scared, just go ahead and Google COVID-19 whistleblower attorneys, and you'll see hundreds of pages pop up of plaintiff lawyers in this area that are actively soliciting clients that are at the ready to bring a claim, whether it's based on some sort of outright fraud or at least more ambiguous abuse situations that we've talked about. The way to protect yourself from the risk of whistleblowers, and it's not necessarily possible to insulate yourself from that risk entirely, I think, is to do a couple different things. One is to limit your analysis of eligibility criteria and things like that to a core group of decision makers. You shouldn't be taking those questions, especially if there are doubts about whether or not you can properly make a certification. You shouldn't be sharing that information with somebody within the company that isn't ultimately responsible for it. You shouldn't let word of those question marks in a lot of ways extend beyond a narrow group of your leadership team. The second protection is establish a formal internal reporting structure that allows employees that have any concerns to raise them internally. In a lot of cases, confidentially, I think is best practice. And there are a couple of reasons I think this is important. Number one is it gives employees a mechanism for raising concerns without going so far as to pursue a Quitam claim. It may make it harder in a lot of cases for terminated employees, which Brian, I think, mentioned at the outset here, that you see most whistleblower claims are brought by former and in a lot of cases disgruntled employees. It may be harder for them to claim or accuse you and your company of having knowledge of their protected activity to prevent any sort of retaliation claim under the FCA's whistleblower protection if they didn't actually pursue those formal avenues to call this to the company's attention. And then really an internal reporting program provides your company information far earlier than you would get it if there's a whistleblower claim, a Quitam action that's been filed under seal. You're not directly going to learn about until it's been unsealed. So it gives you the tools that you need in a lot of ways to alter your actions, to evaluate what it is you're doing, and then based on the information you gather as part of that investigation, to consider whether or not you ought to be self-reporting to the government. Again, this is something I think we've talked about a couple times, that there is an expectation at the government level, that if you discover wrongdoing, you're going to make a timely and proactive voluntary self-disclosure to the DOJ or the local U.S. Attorney's Office, and that you're going to be prepared, of course, to reimburse the government for the funds that were wrongfully received or withheld or applied for. The FCA itself incentivizes voluntary self-disclosure. It provides for double rather than treble damages in cases where employees voluntarily self-disclose within 30 days of discovery. The caveat to that, of course, is that in order to be qualified for that or eligible for that reduction, the disclosure has to be made before the company gets wind of an FCA investigation, or in some cases a whistleblower claim. You can't get wind that the government is actively investigating you or has concerns about something you did, and then expect to get credit and turning around and saying, "You got us, here you go, here's your money back." That's not really how it works. And so that's something that's a difficult question to ask yourself and to answer in a lot of cases, whether or not self-reporting is appropriate. Obviously, there's a financial hit that comes with it. This is something that is especially important in FCA cases. It's another area, again, where I think it's crucial that you consult with counsel. So with that, I know I went a little long, but I'll turn it back to you, Mark, for questions if you have any.
Yeah, thank you, Tom. That was great. You know, we have a few minutes left here till we close out the hour, and but we haven't received any questions. But that said, there's just one thing I want to just pose to this group to close this out. We've heard about the overall structure of the Act, enforcement initiatives, specific COVID-19 enforcement, how we can protect ourselves. But what if one of our listeners finds themselves, you know, in the middle of a oh boy moment? We did something wrong. For example, in a PPP loan app, in retrospect, you know, maybe we didn't have the financial need criteria that's prescribed by it. What if they just pay it back? What if they just take a loan and pay it back? Do you think that liability only lies where someone then goes and knowingly seeks relief from payment? Or can you even have liability where you pay a loan back? What do we think as a panel on that? Because that is something I've heard from others as a question.
So, Mark, the article that I referenced earlier by the former division head of the civil division for the DOJ referenced that in that interview that I talked about. And Tom just talked about how voluntary disclosure can lead to credit in reducing your damages, but former Attorney General Hunt was making the point that it can eliminate or reduce your liability if you take that further step of getting, you know, obviously consulting with counsel first, but contacting the government before even it would be appropriate for credit purposes.
Yeah, I think it's the starting point. It's not necessarily the end point. You know, returning the money is necessarily going to raise questions, and so how you do it, what you say when you do, I mean, that's where we get into the nuances of whether to self-report, how to self-report, certainly mitigate risks and or exposure. It doesn't necessarily eliminate it, but it is, I think, important, because if you're found to have concluded at an earlier point in time that you shouldn't have received these funds, and then 2 years later you get hit with a enforcement action brought by the government, or you learn that there was a whistleblower action pending. But number one, it's really bad evidence for us in defending it, and number two, it's a factor that I think the government is going to be considering when deciding what's it going to take to resolve this. And at that point in time, it's too late to simply return the funds that you're going to get hit over and above that.
That's right. That's right. Yeah, you know, the regulatory guidance that's come out in the FAQs and the like has been at times clear as mud or inconsistent, and but you know, we don't have a track record of enforcement or decisions yet about the impact of that. But I agree with you both that it's a point of mitigation. You have to, of course, make the decision in consultation with counsel, and it is important about what you do, how you do it, when you do it. But I will say this: I'm very familiar with False Claims Act cases where goods and services are delivered according to specification. There's compliance all the way around, but someone has made a false statement in getting into the program, getting eligible for benefits, set-aside program, preferences, things of this sort, and the government wants the whole amount. They want the whole amount back, or they claim that as damages as a theory of prosecution in a civil or criminal case. So, you know, it remains to be seen, but I think that is, I think they're going to, as someone pointed out earlier, low-hanging fruit initially, but as this evolves, it will expand, and so again, the importance of having outside counsel guide you through this. So,
Mark, just to touch on that quickly, I think, and we've talked a lot about PPP. I don't need to focus on that exclusively, but this goes. Part of the answer to that question, I think, the government's going to be looking at what the impact was on other potential participants in programs like that.
That's
FCA
right.
ran out of funding pretty quickly, and so there were a lot of small businesses that weren't able to apply for loans. And so if you received a PPP loan that you weren't entitled to, and you wait 10 months to return it, I think that's a factor that the government's going to be considering when assessing ultimate liability and the damage that's been done as a result of what they consider a fraud on the government.
Nothing, it doesn't confer immunity, but it does, it could mitigate. And again, that's a strategic decision that is done in consultation with counsel. So, all right. Thank you for your attention, for joining us today. You should feel free to reach out to any of us individually if you have questions. We're here to help, and we hope the program gave you some helpful tips on the landscape here and how to manage it. So thank you very much.